Getting ready to get started here in about 2 minutes. Welcome, welcome. My name is Cheryl Thomas from Global Rights for Women. Really happy to see all of you joining us. We'd love it if you would like to put your information in the chat box so we can see where you are coming from. We've been delighted to have in our past webinars folks from all over the world and many folks that people know, so it's nice to see that if you're interested in doing that. Wonderful. Oh, here comes some chats. Texas, great. Colorado, wonderful. Oh, great. Ottawa, wonderful. COPFS. Good morning from Canada. Hello from Minnesota and Scotland. Ohio, welcome everyone. So happy to see you. From a sunny garden in lockdown. Love it. Oh, from Estonia. Pile is there from Estonia. So happy to see you. Pile is the executive director of the WAVE network in Europe, Women Against Violence Europe. You may know her from Maine, Glasgow, Des Moines. Oh, wonderful. That's where I went to college, in right south of Des Moines, Iowa, Indianola. Okay, are we at the top of the hour here?
Yeah.
Okay, I think we should get going then. Again, greetings everyone. My name is Cheryl Thomas and I am with Global Rights for Women, and we're here in Minneapolis, Minnesota, and we're just thrilled to have our colleagues from Scotland joining us in the second part of our two-part series webinar on coercive controlling violence. And in this second part, we will be discussing the enforcement of the criminal law in Scotland. And some of you may know that this is a unique law and really, in my view, so progressive. And we're interested in hearing from these panelists we have here today with us about the practicalities of how it came into being and how it's working. So let me go to the next slide. Nazifa will tell you a little bit, my colleague Nazifa Wazirzadeh will tell you a little bit about the logistics of the webinar.
Hi everyone, like Cheryl said, I am Nazifa, the program coordinator here at Global Rights for Women. And a few logistics to start off. Feel free to type your questions into the question feature throughout the entirety of the presentation. And Cheryl and Laura Wilson, our staff attorney, will work together to get those questions to our panelists. And a recording of the presentation and the slides will be sent out to all of you that have registered. And look out for CLE accreditation because that will be requested for Minnesota lawyers. Thank you.
Great. And my colleague Laura Wilson is also here with us, and she's our attorney at Global Rights for Women. I think she's going to turn her camera on right now so you can see her face, and she is going to be monitoring the chat box. So we found that this is a good way to, as much as we can in this with this format, engage all of you in the dialogue and conversation. So she'll monitor the chat box and pose questions to me and to the panelists as we go forward. So please don't hesitate to put those questions in, and we will definitely leave time to discuss questions during and at the end of the webinar. So just a little bit about Global Rights for Women for those who don't know us. Oh, I see Linda McDonald has joined too. Really going to be interested to hear your thoughts, Linda, a leader and Jeannie, great, in advocating for domestic violence to be looked at as torture. Great work that they're doing. Our organization, as I said, is based in Minneapolis, Minnesota. We work with leaders around the world to advance women and girls' human right to live free from violence through legal reform and institutional and social change, which are really all of the same package. This is what our message constantly, that the legal system cannot work effectively for victims of violence or law enforcement, and vice versa, without each other and without absolutely the leadership of the advocates working on the front lines with victim survivors. So all of those things are in one package, and we're really working to change entire communities to better protect women and girls' human right to be free from violence. We can go forward now. I'm going to ask the panelists then to introduce themselves. We're just thrilled to have you with us. Why don't you go first, Mhairi? Got to unmute yourself, which is always
an idea to unmute oneself. I'm Mhairi McGowan. I've spent over 25 years in the violence against women movement. First of all, working in a shelter, and then setting up and running Scotland's first and largest domestic abuse court advocacy service. I'm now an independent consultant and trainer, and my focus really is on building strategic and operational change.
Wonderful. Thank you, Mhairi, for joining us. Anne-Marie.
Hi there, really delighted to join you all today. My name's Anne-Marie Hicks. I'm the National Procurator Fiscal, which is the name we call it in Scotland. I'm National Prosecutor for Domestic Abuse. I've been a prosecutor for 22 years, still find it hard to believe. I was appointed to this role almost 7 years ago. It was a brand new role created by the prosecution service to really focus on domestic abuse and to bring some strategic leadership to it. So I've worked really closely with Mhairi and Sam throughout this period and before, and really excited to be here to talk about our law.
Wonderful. Thanks so much, Anne-Marie, for being here. And Samantha.
Hi, I'm Sam McCluskey. I'm the Detective Chief Superintendent, Head of Public Protection for Police Scotland, which includes domestic abuse, but also has wider departments, including sexual violence against women and girls, registered sex offender management, child protection, adult protection, etc., and have been involved in domestic abuse and have a special place in my heart for that, with Mhairi and Anne-Marie, as they said, for a long time. Previously was the head of the National Task Force, so actually outside tackling domestic abuse and arresting people. So, and I've been a police officer now for 27 and a bit years.
Wonderful. Thank you so much again, Sam, for taking this time to be with us. And then just a brief introduction of myself. I've also been working, it sounds like about the same amount of time, on violence against women issues internationally, back kind of right when the United Nations first said that women's rights are human rights in 1993, and violence against women is a human rights violation, and have had the great privilege to work with many folks in Minnesota and around the world on new laws that are aimed at better protecting victims of all forms of violence. So it's been a great honor to do this work. And I'm going to start out with this first slide and bring our panelists in here in a minute. But our work at Global Rights for Women is rooted in the premise with domestic violence. There really needs to be an understanding, particularly with legal and law enforcement interveners, of the three types of domestic violence, because the solutions and the responses of the entire community, including law enforcement, prosecutors, judges, probation, have to be different with each of these types of violence. Coercive controlling violence is what we're going to be talking about today. And I'll just introduce that topic briefly, and then we'll say a few more words about it as we go on. But this is the pattern of violence. It's the most common form of intimate partner violence. It includes both physical and other tactics of abuse. This type of violence is most commonly used by men against women. Resistive violence is sometimes legal and it's sometimes not legal. We think of it sometimes as self-defense. That's motivated by a completely different force really than coercive controlling violence, which is motivated by power and control and the quest for power and control. And then the third type of violence we talk about in our work and our trainings is domestic violence unrelated to coercive control. And that can be violence that, that comes from mental illness or may come from one incident of anger or jealousy or a drug problem may be the core cause of this violence, but they're very different and they require very different responses from our communities. And I know that you folks in Scotland have just some different terminology there. Anne-Marie, would you like to chime in there and explain how you look at these forms of violence? You're muted, Anne-Marie.
As a rookie mistake. We are familiar with the terms that you've discussed. Our police and prosecutors training concentrates as well on the different typologies of abuse. Some of the training we have on that is around the US professor Michael P. Johnson's work, where he talks about intimate terrorism, which is the term he uses for coercive control, violent resistance, and then situational couple violence to really reflect domestic violence, which is unrelated to coercive control. We've found training prosecutors on that to be really helpful, just to, as you say, understand the differences. We always caution against trying to fit things too easily into boxes, because sometimes if you don't have all the information, it isn't always clear, and what can appear as one thing might be part of a bigger picture. So I think it's always really important that people are aware of that, and also to reflect that some of the cases of violence, domestic violence that are not involving coercive control, can also themselves be really serious and result in serious harm to victims and children. So many of those cases will still be prosecuted, albeit that they don't involve elements of coercive control.
Okay, great. Anything to add there, Sam or Mhairi? Okay, we can move on here then to the next slide. Coercive controlling violence is this is the exact language that Evan Stark, professor from New Jersey here in the United States, has so beautifully described what we're going to be talking about here today, and really identified this, this concept of coercive controlling violence that those of us who work in the domestic violence field have seen throughout the years or decades of our work, a strategic course of oppressive behavior. So that pattern of behavior that's designed to secure and expand gender-based privilege. I'll say something quickly here. In my experience, when I read this definition for the first time, I felt just really a huge relief. I had been working for years, starting in the 90s and early 2000s, with folks around the world who were drafting their first domestic violence law. And we hear over and over again, and this is, I think, so common, where victims will say the worst thing was the psychological abuse. And so that ended up actually in lots of the laws. It ended up in the definition of domestic violence in the language of laws that many were drafting. And it caused me, at least, concern, because I felt that that term psychological abuse could be so easily manipulated by abusers. And they do manipulate laws and use that against, in fact, a real victim of violence to claim that entitlement to an order for protection, or example, based on some kind of psychological violence. I felt that it was too vague, really, to be used in the courts. So when I saw this this definition and then the kind of the language that came out of it, I thought, now that's what we need in laws to really get at what so many women are experiencing in their homes, not these one-time incidences of violence that our criminal laws are so were created for. Strangers on the street. They language and the response of the justice system that follows that so often couldn't get at the real abuse that women were facing in their home. So we can go on then to that next slide. And this, again, many of you are familiar with the power and control wheel. I know that you can't read it on this slide, but again, a really important tool to be understanding coercive controlling violence, this motivated by power and control. This power and control wheel was created in Duluth, Minnesota many decades ago. Duluth is about 2 hours north of where I'm sitting right now, and it's been translated into many languages, found to be useful and reflect the experience of so many victims around the world. Just about everywhere we have trained, this resonates with those that are working with victim survivors. And so you can see on the outside, the physical and sexual violence punctuates the daily use of coercion and threats and all these different spokes that you see, using intimidation, using isolation, such a powerful thing during COVID, of course, minimizing, denying, blaming, using economic abuse. So these tactics are still very much in play with abusers around the world. I just encourage everyone, if you have a copy, get this out, and during these times in particular, when these tactics have been given a particularly nurturing forum for abusers as we're in isolation. And we need to remind ourselves as first responders in our communities that this is going on probably in an exacerbated way right now. So we can go on to the next slide. So I am going to stop talking myself here and bring in our colleagues. So Mhairi, I'd love to talk with you about, what was it that was the inspiring kind of dynamic in your community that was happening in Scotland and inspiring this law to be created? Maybe we can just start with some background here from you, Mhairi, as an advocate.
Yeah, of course. And what you said there about the power and control wheel really indicates that holistic nature of the abuse that women face. So from an advocate's point of view, women were frustrated that holistic nature, that pattern of coercive controlling behaviour wasn't reflected in their experience when they reported incidents to the criminal justice system, because the criminal justice system focused on individual acts of violence. And over the years in Scotland, the feminist movement, violence against women agencies had talked a lot, over 40 years, had discussed within ourselves and also at other times with others, saying, what kind of law would we need? We needed something to change that would speak to women's experiences. And then I suppose a defining moment really was the re-establishment of the Scottish Parliament in 1999, because that gave an opportunity to harness different voices. There was cross-party support for seeing domestic abuse, or the eradication of domestic abuse, as a national priority. And there were huge positive changes right from the beginning. But the fundamental question around the state recognising the holistic nature of that violence and the enormity of women's experience remained. So that was still a difficulty. And I suppose there was the start of the domestic abuse courts. We were way behind you guys in America. Our domestic abuse court, our first one was in 2004. And when Assist was set up, the advocacy service Assist was set up as part of that process, then we started to issue a weekly bulletin that was sent to MSPs, members of the Scottish Parliament, to decision makers, to people in all sorts of strategic and operational arenas. And really it gave real-time feedback on a weekly basis of women's experience. And that was a consistent message that showed the ability of the criminal justice system to capture that experience, was failing in a way. But of course, we weren't the only ones who were feeling like that, and who were seeing that there were problems. Anne-Marie, would you like to take it from there?
Yeah, sure. I mean, I think it's fair to say that probably for a long time, it really wasn't understood, coercive control, by authorities and by those in enforcement. So I suppose we were used to dealing with violence and threats and these kind of offences, but the kind of nuances of coercive control and a lot of the deprivation of liberty and the isolating tactics were perhaps not understood, and I think that is fair to say, and the pattern of that. But I think what we've seen over the last, certainly in Scotland, I would say the last 15 years or so, there has been an increasingly specialist approach taken to domestic abuse by police and prosecutors. We'll have a few specialist domestic abuse courts. I set up the first domestic abuse prosecutors specialist unit around the Glasgow Domestic Abuse Court. And what was interesting in those days, before we really, I think, knew a lot of the learning on coercive control, we still saw it in the cases, because we would say, oh, this is a power and control domestic case, or no, this is a bad time in a relationship case. So we were already making those distinctions, perhaps even without the kind of academic background to it at that stage. But I think having that increasing specialist approach, and then, I suppose with my appointment as well, it was a real focus by the prosecution on that, and the police had a number of specialist units set up as well to really tackle domestic abuse. And I think as you start to do that, your training, there's more investment in that, and you learn more about it. You then, as well as engaging a lot, I would say, with the women's sector, and I think we would always say that has been the probably biggest factor in how we've developed our learning and understanding of domestic abuse. But I think as you start to do that, you're becoming frustrated as well, because you start to see more and more what the limitations of the law are, that we can prosecute attacks on people's physical integrity, but much less so when the attack is on their psychological integrity, and on their person in a non-physical way. So I think there was definitely, over the last decade, there's been a real growing appreciation of that amongst police and prosecutors. I don't know, Sam, if you want to take it on from there.
Sam, you have anything to say? You need to unmute yourself, Sam.
Sorry. I think I would definitely agree with everything that Anne-Marie and Mhairi have already said. And from a policing perspective, going out to deal with people who were in crisis and actually responding to reports and people calling for help, and a lot of the behaviours didn't meet the criminal threshold, and it was very frustrating for us because we could see the impact. We started then actually in work with Mhairi and Anne-Marie to develop specialist training and specialist teams across the country, and we've got a lot of tactics that we deploy in terms of domestic, looking at previous relationships and going back to previous partners. But even doing that, it didn't tackle the coercive control or the emotional abuse that we were seeing. So you could include it in reports, but actually we couldn't take any action on it. So it was really, really frustrating. And then when we did engage with the women's sector, as Mhairi said, it was very enlightening for us because they actually explained what we were seeing.
Wonderful. Okay. Thank you for that. And I think maybe we can go to the next slide and hear you talk about this critical period, kind of from 2013 to 2015, when these experiences you're discussing coalesced, and there was a conference with the prosecutors and a high-profile case, and things crystallized into codified change. So, Anne-Marie, would you like to talk about, well, any one of those bullet points there? Maybe start with the prosecutors conference or the high-profile case.
Sure. I mean, I think as we were saying before, there was that growing frustration, the limitations of the law, and I think the high-profile case really reflected that. You know, it was a member of Parliament who was prosecuted for a number of offences over a long period of time, but actually what we were able to prosecute for were effectively physical violence offences, and it didn't reflect at all what his victims, and there were multiple victims, had been subjected to over a long period of time. And so I think there was a lot of media coverage given the high profile nature of the person, but I think it really put into the spotlight what we'd been seeing, you know, as an emerging pattern. I was appointed to my role about September 2013, and I carried out a review at that stage of our policy and practice in the prosecution service. And at the conclusion of that, we arranged to have a conference on domestic abuse. So we had that in May 2014. We had about 150 delegates at it. And at the conference, the former Solicitor General, who's one of the senior law officers who, along with the Lord Advocate, heads up our organisation, she gave an opening address at the conference and really caused quite a stir, because in her address she decried the adequacy of the criminal law provisions in Scotland for domestic abuse, and said that although we have cases that we do successfully prosecute, in many of those cases victims are left at the end of that feeling that their experience as a victim of abuse hasn't been recognised by the courts, because instead of being able to reflect the true experience that they have gone through over years and months, and all the instances and behaviours that they've been subjected to, the criminal law tended to focus on isolated, discrete incidents, and it tended to be on violence, threats, sexual violence, because that was all that was against the law at that time. And what she said was that taking that kind of episodic approach can really lead to minimisation of the abuse by the criminal justice system. And she called at that stage for consideration of a bespoke domestic abuse law. So it was really significant, I think, having someone who's one of the most senior law officers in the country, who jointly heads up the prosecution service, coming out and saying basically the law of the land is inadequate. Everybody really had to sit up and take notice. But I think what's important, and following from what Barry said, this is something that had been highlighted through the women's sector for a long time, and had been coming up in cases through the press. So it wasn't in a sense coming from the prosecution service, you know, out of nothing. You know, this was I suppose a growing feeling, but I think having that high profile person again and that platform to raise it really was a catalyst for change, actually, and for getting some momentum about the development of the law.
Great. And you were talking before when we were preparing how important it was, Mhairi, actually you were saying how important it was to have a kind of a base of trust with the advocacy community and the justice system. And maybe we can bring you and Sam in to talk a little bit more about that.
Yes, it was an exciting time in a way, because we had the beginnings of Police Scotland. We had all the different police forces in Scotland had merged into one. The Chief Constable was committed to the issue of domestic abuse. We had the Lord Advocate and the Solicitor General talking about domestic abuse in the way that Anne-Marie has described. And all of a sudden, as an advocate, it really felt that we were at a moment in time that if it could be harnessed, if all of that feeling could be harnessed, we could really change things and make a difference. But there was also, of course, it was a difficult time too, because for progress to be made, there has to be trust between the advocacy sector and between the criminal justice system. And if you're, as an advocate, you're listening all the time to the limitations of that, then being able to hold that strategic notion of building consensus and moving forward and trying to ensure that we're all working together for the one goal is not always easy. But we did that, I think, because there were a number of us, and not just the three of us that are here today, but a group of us and various agencies in Scotland all saying the same thing. And that trust that we were able to build, I think, really made a difference. It made a difference to ourselves as individuals. It made a difference within our organisations, because it became clear that every organisation was looking for solutions. So from an advocate's point of view, I didn't feel that I was banging my head against a brick wall all the time. I knew people that I could talk to and say, this is a problem, and it would be taken seriously. So it was a real moment of change, I think.
I just want to acknowledge what you said, and particularly at this time in our world right now. I'm sitting about 2 miles away from where George Floyd was murdered here in Minneapolis. And we are experiencing this catastrophic, really sense of failure of this trusting relationship between the police and particularly, the vulnerable communities and communities of color and immigrant communities. And I want to note that. I want to acknowledge that this can happen, that the police, and please jump in here, Sam, if you have some things to say, that there are places where police can serve the community in a way that is that creates this trust and really in partnership with the advocacy communities, listening to the voices of the vulnerable, the oppressed, those who suffer intersectionalities of oppression, like Black women in Minneapolis who are afraid to call the police because they're afraid their husbands will be hurt. So I just really encourage you, Sam and Mhairi and Mhairi, to talk about that as much as you like and you can during this webinar about how that trust can be regained. Anything from you, Sam, to add to that as a police officer?
Yeah, so I think everywhere has similar issues when it comes to violence against women and girls. And for us in Scotland, it wasn't easy, it wasn't overnight. It's actually still happening. It's an ongoing process from 2013, 2014, but it was a real significant culture change. So we police by consent in Scotland, and Police Scotland is made up of the communities that we serve, and hopefully we try to be representative of those communities. But the whole trust building exercise that Mhairi mentioned was a real two-way thing. So internally, we had to change culture and we had to change attitudes of police officers around domestic abuse, that it was a serious crime, that there was significant impact on women and children and families and wider communities from these individuals. And that was a slow process to start that. And then we also, so I think traditionally, Mhairi, I don't know if you'll agree or not, traditionally some of the relationships between the police and the advocacy services were not very trusting. We didn't engage very well, we didn't work particularly well, and we didn't share information. And I think part of the building block for that across the country was to get together. We're never going to agree on everything, but we've all got a common goal to keep people safe and to help these vulnerable individuals who are being exposed to that. And the only way we can do that is actually to work together. So Mhairi and I then embarked, and then Mhairi and I and Deborah, one of the other girls in my team, embarked on kind of a tour, if you like. And we travelled the country and we spoke to senior officers, and we spoke to officers on the ground, and we spoke to advocacy services in different pockets of the country to say, if we can, stand here together and say that this is everybody's job to do this, we all have to work together, then that can make a difference. And I think it actually did make a difference, Mhairi, and it was that whole joint, we're doing this together from the start, and agreeing objectives and agreeing how we were going to work together and agreeing information sharing and being as open and transparent as we could be within the law. That was a huge starting point for us. and a very slow process, but a culture change across actually not just the police, but advocacy services as well.
There was a huge issue about whether, if you think about the amount of information that comes to advocates, then women who experience domestic abuse will give you all sorts of information. So we would hear all sorts of information about various different issues that, people that were involved in drugs or whatever. And we, following a lot of discussion with the police, we took the decision to share information with the police. We were very upfront with our service users and our clients about what we were doing and why, and they were relieved because it meant that they had they knew that if their partner was involved in dealing drugs, then rather than that being used as a weapon by the perpetrator, then actually they could tell us, we could tell the police, and that could be targeted separately, but would have the effect of helping the victim. So that was very controversial within the feminist movement, incredibly controversial, and there was a huge resistance to it. But I have to say that that leap of faith that we made certainly made a huge difference. And I think now, looking back, it's now no longer really controversial. Now lots of different agencies do that now, not just the one that I was involved in.
I can't let that go without just really acknowledging you all, and in particular the justice, law enforcement and justice system, who really listened to you, Mhairi. I heard that from Sam and Anne-Marie as the person with daily contact with victims, and your colleagues, of course, too. Letting that experience guide the community and legal response to violence against women is so important, to listen to those for whom the system, the law enforcement system, is not working. And what a lesson, again, we need to hear from you today in the United States. Let me just ask you panelists if there's any other points you'd like to bring up on from this slide. We could go on to the next slide, is the language of the Scottish law. And then I would ask Laura, before we do that, if there are any questions we should stop and pause here from the participants and answer. But first, I'm saying a lot of things there. On this particular slide, Sam, Anne-Marie, Mhairi, do you have any other points you want to add from this? Okay, you're good. Okay, so Laura, well, I'm sorry, Laura, I didn't let you introduce yourself and say who you are. Would you do that and let us know if there's any questions too from the chat box?
Sure, I'm Laura Wilson, and I am the attorney at Global Rights for Women. And we do have a couple of questions. One is for Samantha, wondering if you have a written framework for how you work to change culture and beliefs among police in Scotland.
A written framework for the culture change, I guess not particularly, but we did it at every level. So senior officers right down to the officers on the ground were all given training. We went out and we delivered face-to-face presentations. We used case studies. We talked about, as Mhairi mentioned, the sharing of intelligence and all the different ways there are to tackle perpetrators that don't necessarily always involve the victim, but sometimes you can actually remove the risk another way. And so that was about engaging face-to-face with as many people as we could across the country. I'm not sure we actually wrote it down as a strategy. We probably should have. We just did it, if I'm being honest.
I think the important thing was that the Chief Constable declared it a priority. Yeah. And just said, that's it, it's a priority. So therefore, that message, I think what also was very helpful was because you're such a hierarchical organisation that if the Chief Constable says this is a priority, then the rest of the organisation jumps.
Good point. Leadership. Boy, the power of leadership.
Thank you. And then I have a suggestion from Anne Hain, who I believe you may know, some of the panelists may know, to explain the 5 stages of the intelligence process and kind of how that's relate to what you've been discussing.
Okay, so I don't know that it's really, I might just compress it rather than 5 stages because it's quite, so essentially what would happen is a victim might engage with somebody from an advocacy service. I think this is what Anne's talking about, the sharing of intelligence through the advocacy service. They might give information about their partner being involved in drug dealing, for example, and that information would be passed to the police. So we actually developed an electronic solution for that so that there's a portal so that the advocacy service can put it on. They just need, they get access and a password from us and they put it into the system. They can't get into the system, but they put it in. We then assess that intelligence and we sanitize it. So we take all the source information out of that to protect the source, to protect the advocacy service, primarily to protect the victim. And then we'll sanitize it and we'll assess it. And sometimes it will be actionable intelligence, like John Smith is a drug dealer and he deals from this street corner on a Friday between 8 and we will then pass that out to maybe a local policing team or maybe a dedicated unit to actually address that problem and then feed it back in. But the firewalls are in place that the people that are dealing with that intelligence never know where it came from. They don't know that it's linked to a victim or anything like that. So hopefully that in very simple terms explains what we do with it.
Thank you. And the questions are rolling in, Cheryl. I have a couple more. Is this a good time or should I hold off until later?
I think this is an okay time. We're just
Okay.
at 10, so yes.
Great. So there's a question, have there been connections found between the coercive control law and preventing femicide?
Sorry, Laura, can you repeat that one?
Yes. Have there been connections found or established data collected maybe between the passage of this law and the prevention of femicides?
Suicide or homicide?
Killings of women.
Oh, homicide. Right, okay, sorry. It's not the best line. We don't actually have that data. Obviously, the law in terms of coercive control has only been in place since the 1st of April, or implemented since the 1st of April last year. So we would let that run and then we would start to examine it now.
Really good question. That'll be very interesting.
Yes. And then another question, does Scotland have mandatory arrest? And well, I guess this is 2 questions. Does Scotland have mandatory arrest? And was there a budget for the change in priority for domestic violence, or were resources shifted in order to support this kind of additional work?
Okay, so the first question in terms of arrest, we have to have a sufficiency of evidence, but we can arrest on suspicion and then continue our investigations. And at the end of a set period of time, so we'll only have so many hours for somebody to be in custody, we have to make a decision. So we either arrest and charge, or we release them on investigative liberation, which is like police bail, and allow them to go back to a different address, and we'll continue the inquiries, but we will put protective measures around it so that the victim is kept safe, or they might be released on an undertaking to appear at court. Again, we'll put conditions around that we will proactively police to try and keep the victim and the family safe, or they might be released without charge if we've not got enough evidence. Not every domestic incident that's reported to Police Scotland has a criminal aspect. We do have non-criminal domestic incidents that are reported into us, but for the ones where the officers identify criminality, they will try and arrest on suspicion and then do their inquiries, further inquiries.
Thank you. And then the second part of the question, I think maybe any of the panelists could speak to, is whether there was a budget for this change in priority or the addition of coercive control, or if resources were shifted.
Well, I think when the police changed their prioritisation of it, we noticed quite starkly an increase. I think it was around about 35% increase in domestic abuse charges reported. That was around 2013. It was really stark, and obviously that has a huge impact on the courts in causing delays. And we were really concerned, and again, this is where the joint working came in, because through close working with Mhairi and her team of advocacy workers, we were hearing about the real impact of delays in court hearings taking place months and months and months after someone was arrested. And so we were able to advocate for extra funding and for action to be taken at, I suppose, a government level to address that. So government targets were introduced for domestic abuse cases to be heard within 8 to 10 weeks of the first appearance. So that would be for a trial. And obviously there needed to be extra funding for that. So the prosecution got some resources, the court service got resources for extra judges, extra courts, we get extra prosecutors. So there was money made available for that. I can't speak to the police resources, but certainly we have had resources to reflect the change in prioritisation and the increase in business, and that has been really useful because it's allowed us to bring those delays right down. Unfortunately, as I think we'll talk about towards the end, the COVID-19 crisis has single-handedly scuppered that completely, but there was great progress being made in having domestic abuse trials within 8 to 10 weeks as a result of that work and that funding and change of resources.
Okay, thank you everyone for your questions. I think we can move on, Cheryl, and then just save a little time at the end for some more questions.
Okay, yeah, I do want to address the one from Brenda, but we can.
Oh, I didn't see that.
Yeah, that's an important question too. I'd love to hear before we get too far off topic. I want to clarify that because I'm sure that's not what Sam meant.
I don't see this question, Cheryl. Could you pose it?
Brenda asked, do you mean that the abusive partner is taken out of circulation and the woman is protected via arrest for other issues? I don't think that's what you meant. Right?
No, so
okay.
does that question relate back to when we were talking about intelligence? And perhaps when the person is arrested for other criminality? Is that what Brenda is meaning?
I'm not sure. Maybe we can. Brenda, will you elaborate on that? And we will make sure we understand and come back to that question. And Laura, if you would monitor that, that would be great, because that's important for people to know that certainly you weren't arresting women. I want to make sure people know that. Thank you, Brenda. Okay. So why don't we then move on and to the language of the Scottish law? And we've got Anne-Marie, would you like to just kind of take this over and talk about why it's written like it's written? And we'll all notice that there's no coercive, there's not the word coercive, and I guess there is the word control, but love to hear you talk about that.
Yes, so we had discussions around the wording of the legislation at various points. So from very early stage discussions in the working group that we formed, multi-agency group that followed the conference, there was discussions around that, and through subsequent consultations the government had on it. And I think the concern was that coercive control as a term is well understood by those in academic circles and in the women's sector who are involved in this kind of area. And for those of us in enforcement who are involved in this, we understand it, but a lot of people wouldn't necessarily understand it. And we felt it was important that the law was easy to understand for the public. For victims, for potential perpetrators, it's important that law enforcement understand what they're trying to enforce. So the police, prosecutors, important for the judiciary to understand in the courts. And And also in terms of trying to educate society, if you put a term that people are maybe not familiar with or make their own interpretation of, then that can cause issues as well. So it was felt to really focus on the behaviour, and we'll come to that, I think, in the next slide when we look at how it's defined effectively in the behaviours. But the offence in itself, it criminalises a course of abusive behaviour between partners or ex-partners, and in Scotland that's how we define domestic abuse. I know in other parts of the United Kingdom and elsewhere, in some other jurisdictions, their definition of domestic abuse is wider and brings in familial abuse, but in Scotland it's restricted to partners and ex-partners. And so this course of abusive behaviour is on at least 2 occasions, but in our experience from the cases reported, it's frequently many more than 2 occasions. And in terms of the way it was framed as a course of conduct, I think this was really important in a couple of ways. Firstly, because it addressed that issue that the Solicitor General had mentioned right at the start, that it is a pattern, it is a course of behaviour, it's not a one-off discrete incident. So the law was going to reflect that and allow us to include within a single charge a whole range of different abusive behaviours to try and better reflect people's experience. But the second thing was evidentially, for prosecutors to prove, it makes it easier. So in Scots criminal law, we have what we call the requirement for corroboration, and essentially what that means is that we have to have by 2 sources of evidence to prove both that the crime was committed and the identity of the perpetrator. And as you can imagine, that's very challenging in a domestic abuse setting where the majority of incidents happen behind closed doors and there can be more limited evidence. So by having a course of conduct offence, the beauty, I suppose, of that is that we can include allegations of behaviour which, if they were standalone incidents, we wouldn't necessarily be able to prove, but when taken as part of a course of behaviour, we can include them, provided there is a sufficient underlying nexus and communication between the behaviours to form part of a course of conduct. So I think that's a real strength of it, and that allows us to include those behaviours. And the 2 tests that they introduced on top of that were that a reasonable person would consider the behaviour, the course of behaviour, to be likely to cause physical or psychological harm. Now, psychological harm, I was interested in your comments earlier, Cheryl, about the concerns around using the word psychological. And so in the law, they specifically defined that as including fear, alarm and distress. So they weren't talking about a clinical diagnosis being required. They were acknowledging that psychological harm is wide and it includes those things. But the reasonable person test is effectively a threshold test. It's that behaviours are criminal because they're likely to cause harm. And I think that's important, that there's a connection. It's not just about the behaviours, it's acknowledging the likelihood of causing harm. But what I really like about our law is that the reasonable person test is an objective test. It's about likelihood of harm. So we don't need to prove that the victim suffered actual harm. The focus is very much on the perpetrator's behaviour and not on any impact on the victim. And that's really important because not everybody, will display an impact, particularly when we're not talking about violent behaviours. People we know minimise behaviours due to the nature of abuse. A lot of behaviours are really hidden, and so for people, they won't always have a very overt, visible impact. We also know that some people are very resilient and have different reactions. So it was really important for us that the law was consistent and it didn't allow perpetrators to evade justice just because they happened to choose a victim who didn't display an impact or was perhaps very resilient. So the reasonable person test of likelihood to cause harm, I think, is a real strength of the law. And the last part there in the slide is really the criminal intent. So every offence has to have what we call our mens rea, or criminal intent. And in this case, it's intention or recklessness to cause harm to the person. But I think the important thing in all of this is the law recognises it's not about whether each individual incident causes harm, because it's recognised there could be lots of small incidents along the way which in and of themselves someone might look at objectively and say, well, that wouldn't necessarily be really harmful if that was the only thing. It's about the cumulative pattern, and that's what's really harmful to people, is all the different behaviours that build up, and that's where the real harm is caused, and the law reflects that.
Great, thank you. That's really helpful to hear that description. One of the things that I saw in working with these laws as they began to be implemented, and domestic violence, as I said before, included psychological violence, was that then the judge or whoever was presiding over the hearing would require a psychological diagnosis, essentially, in hearing these cases as kind of proof of the harm. So that was something that concerned me, and with this kind of language and this approach, that can be avoided. So we could go on to the next slide. I think is where the abusive behavior is described in the next slide.
I wonder, so I'll say a little bit, but then I think probably Mhairi to talk more about the second bullet there with the behaviours. One of the things that we felt was really important, and there was a lot of discussion around this in terms of the law, should the government just criminalise the parts of the law that the behaviours that weren't already criminal? Or should it be wider to include the whole kind of pattern of behaviour? And we felt really strongly that it should cover the whole of the behaviour, because coercive control, is sometimes, I think, misunderstood as it's just the non-violent part, it's just the psychological part, whereas actually it's a range of tactics that can include violence, can include sexual violence, can include threats within that. And so we felt that if we were going to reflect someone's experience in a course of behaviour, that it was important that we could also prosecute violence, that we can prosecute separately using other tools, but that we could have the potential to put all of that within the one charge. So I'm pleased that the law allows us to do that and include the full range of behaviours. In terms of the definition of how we, I suppose, define the coercive control parts that weren't law, I have to say that was hugely influenced by victims' voices that were fed in very, very strongly, particularly through Mhairi and other colleagues in the women's sector. So I wonder if I'll pass over to you, Mhairi, to kind of explain more of those aspects.
I think the difficulty for us was how do we crystallise the power and control wheel into a small number of statements, really, that would try and encompass that holistic experience that women were having, but that at the same time could be seen and make be able to be picked up as evidence, because we know, for example, how manipulative perpetrators can be. And therefore the issue of how do you define the behaviour, the abusive behaviour, was very important. So what we did was we knew that isolation, for example, would always be part of it, but what else really was at the root of abusive behaviour? And that was when we started to unpick as a group. Anne-Marie's organisation pulled us all together, and we had flip charts all around the wall, and we just brainstormed and then honed it, talked to victims. And there was a real, I think the lead-in time for this legislation really helped, because although my initial reaction was, it'll take ages before this is law, actually it was very helpful, because it allowed that building of consensus to go on all the way through the drafting of the law, as well as the passing of the law through the different stages of Parliament. So when we looked at this particular part, then that regulation that victims talk about, when you've got 10 minutes to get to the shops, and if you're longer than that, you're in trouble. And that restriction of that freedom of action, that restriction of agency, that that we have, you know, you can't get a job, you can't get out to see your friends, all of these different things. And then that it was important also to pick out not just the frightening and humiliation, but that punishing and degrading behaviour that we see perpetrators do that can be specific to a particular perpetrator or specific to a particular victim, where the perpetrator manoeuvres, you know, ensures that there's particular behaviour that speaks to that victim. And then, so the headings had to be broad enough that would pull all of those different aspects in, whilst at the same time, we didn't want to make the mistake, as other jurisdictions had, of listing something that made it look as though you had to fulfil all of this before it could be included. So that was our effort, you know, collective effort of police, prosecutors, and the women's sector, bringing victims' voices. This was our, and the Parliament, of course, the drafting, civil servants, of looking at how we could describe that. And I have to say, I'm even now looking at it, I'm very pleased with it.
It's brilliantly crafted. Great, thank you, Mhairi. Any other comments from the panelists on this slide? But I know people are going to love to hear about the next one. So evidence gathering, and this is certainly something we hear from, or I should say I hear from prosecutors in my work here and around the world, is how do you do it? How do you gather evidence to do this? Go ahead, Anne-Marie.
So this was I suppose the something that has, as you say, it's come up a lot, and people have always asked us, and I think it's something we've always been really upfront about the challenges of investigations in domestic abuse cases. You know, I say because they happen behind closed doors, and I think for us, we recognise that when you're making a law that's going to include more nuanced behaviours, then there may be less physical evidence that you know, there's not maybe going to be the signs of a disturbance in a house or an injury or something similar. So we'll have some of that evidence, but there'll need to be, you know, I suppose, more creative approach to it. And I think we were always really clear that the victim is, you know, almost inevitably going to be at the heart of the evidence. It's their story, it's their, you know, it's their life, it's their reality, and the main principal evidence is always going to come from them. But there are other sources there, so it, you know, and it's really about robust evidence gathering and thinking about other sources. So children being a really important source, you know, given what they're experiencing in a house, but also friends, family members, people who are work colleagues, you know, other parents at the school gate who see these, you know, restrictions being put on people where they're having to rush back to their house to get back, you know, at a certain time. We recognise technology, social media evidence will be a big factor, but other evidence from medical records, from financial records. And I think our experience prosecuting stalking has been really useful. So we introduced a stalking law in 2010 in Scotland. And again, probably very similar nuanced behaviours of monitoring, tracking. And so I think our experience of, I suppose from the police perspective of investigating stalking, but as prosecutors, from knowing what to look for in those cases, I think has really helped with this type of offence as well, that you're looking for lots of different sources that are not just, you know, the I suppose the sign of a disturbance or an injury. It goes way beyond that. But I wonder, maybe Sam could pick up really from the police perspective.
Excellent, thank you.
Yep, so it is quite a challenging law to gather evidence for a whole number of reasons, primarily because it's closed doors. We had to educate the entire organisation. 14,000 police officers have been trained in this legislation and trained in how to gather evidence to prove it. And it was about getting the officers to recognise what the behaviours were and to dedicate resources to make sure that they would spend sufficient time with victims to recognise what the behaviours were. Some of it was a little bit of a learning curve for victims also, when the officers sat down with them or when advocacy services sat down with them, because people didn't have a great awareness of the new legislation at the start. I'm talking about the public victims. So they would almost cherry pick what they think was criminal and give the police that in their statements. So the police would have to sit and go through the entire kind of course of conduct. And because people didn't keep diaries or whatever, it was very challenging to prove timelines. And also where you look to other witnesses, so maybe a neighbour or a work colleague or another member of the extended family, and you ask them for a witness statement, something that appears entirely innocuous to them because they don't see it in context. They see it as an isolated incident. They don't necessarily remember. So it's quite difficult to get all that evidence back in. And sometimes also you're trying to evidence not an action, but an inaction or an omission of an action, depending on the tactics that the perpetrators have deployed. So a really simple example that we use, John hides 10, I would say £1 coins, but that's no use. So $10 bills around the house for Jane to clean, and she must find each dollar bill to make sure she's cleaned thoroughly. And then he decides just to hide 7. And then that sends her into a panic. And does she put an extra 3 in herself? Or so trying to prove an action or an inaction can be really, really difficult. And because it's in private space, makes it worse. But I think the strategic lead from the organisation, from the chief down, through myself, right down through the organisation, is that policing domestic abuse and tackling it is an absolute forced priority for us. So even from 7 years ago when we started this journey, 8 years ago, to now, it actually remains one of our forced priorities to keep people safe and tackle domestic abuse. And I think it's pretty much well recognised, but it is really challenging for the officers, and they're getting better. And I think the volume of incidents that get reported to us and the volume of incidents that they get as sufficient evidence to report them to the prosecutor is an indication that the understanding and awareness is there.
Great. Okay, thanks so much. You can go to the next slide. Thanks, Nazifa. Really important piece that you've described to me is about incorporating children into this law rather than waiting for a standalone law. So, Anne-Marie, would you like to talk about that slide a little bit?
Yeah, this was probably one of the biggest kind of areas of controversy, I think, during the development of the law, because there was quite a lot of lobbying from the children's organisations and also part of the women's sector as well about the need to recognise the impact of domestic abuse on children, and the message really, you know, clearly was that children are victims in their own rights. They're not just bystanders or witnesses, and there was a need to try and do something to capture it. And I think we all shared that. We all shared that desire. I think it was very challenging. There was a lot of discussion about having a standalone offence that related to domestic abuse for children. But I think particularly in Scotland, where we had a definition, or we have a definition of domestic abuse, which is just about partners and ex-partners, it's very difficult to find a way within the law to have a discrete charge around children. And the solution that was identified, which I do think is a good one, is to have a statutory aggravation. So there's an aggravation that attaches to a domestic abuse charge where it involves a child. And part of the beauty of it is that it's easier to prove. You only need one source of evidence to prove it. So it does make it easier. And this aggravation, again, was, I think when the law was getting developed, initially it was fairly basic, and it was more about children who were present. And then the children and women's sector were saying, well, hang on a wee minute, you know, you're affected by domestic abuse whether you're present or not. You know, if you're growing up in a household, the harms from coercive control and behaviour go beyond whether you see, you know, someone, you know, being violent to your mother. You know, it's beyond that. So I think the development of the section on children was really, really important to reflect that children are affected in a number of ways. So the perpetrator may direct behaviour towards them themselves as part of it. He may use them in directing behaviour at the victim. They may be present and or see it here instance, and we know that happens a lot. But also, and I think this was the kind of really far-reaching part, that if a reasonable person considers the behaviour would be likely to adversely affect a child. And I think that was just reflecting that, you know, a child might be adversely affected if they're not allowed to see their family or friends or relatives, or if their mum's not given money so that they can't, you know, take public transport, or they're not allowed to go out, they're not allowed to eat or play with their toys in a certain way. So there's a lot of behaviours that can impact on a child's development. So this aggravator is added to a charge, and if the charge is proved and the aggravator is proved, then the court, when sentencing, has to take that into account in the sentence. So I think it's a really important thing to recognise the impact on children. And I think one of the good things is that the law says that the child themselves doesn't have to be aware of or understand the behaviour. So it means it can apply even if you had babies or very young children who didn't understand what was going on, but are nonetheless likely to be affected. So I do think it is one of the real strengths of the law, that it recognises that.
Thank you, Anne-Marie. Let's go to the next slide about the implementation. And I think we have covered some of that, but want to make sure that you talked a little bit about the training and the importance of the women's sector leading that, and in the, not only in the drafting, but the implementation. So judiciary also was trained, Anne-Marie?
Yeah, so we always recognised that this was going to be a really big change. As Sam said, for the police, they hadn't really had extensive domestic abuse training for the whole force. They had a lot of guidance and training that certain officers perhaps had. So it was a huge undertaking for them, and Sam can speak more about that. We knew that prosecutors would all need to be trained, but one of the, I suppose, the key focus for me since I was appointed was recognising that our training needed to be improved, and we developed a whole strategy for that. So our training had been overhauled in the 4 years up to the offence coming in. So prosecutors had been going on and having enhanced training during that period as well. So it perhaps wasn't as big an exercise, the training for prosecutors. We developed bespoke training for the offence, but the groundwork of all, you know, what is coercive control, how does it impact on victims, what's the nature and dynamics of it, and the risk factors, we had been doing that training for several years. But the bespoke training we did, we had input from the Women's Aid movement. A Women's Aid worker gave inputs to it, and we developed that, and that was really useful for our prosecutors in being prepared. One of the, I think, significant things was the acceptance and acknowledgement by the judiciary in Scotland that judges also needed to be trained. So the most senior judge in Scotland issued a direction that every judge in Scotland would receive bespoke training. So they developed an online resource, the Judicial Institute. They do their own training. They developed an online resource, but they also had a full one-day workshop which all judges in all courts who would be dealing with any of these cases had to come along. I gave inputs to that. The police did. Women's Aid gave inputs. They had a psychologist along and someone from criminal justice, social work as well. So I think that was really important in highlighting these issues and really, I suppose, recognising that this is a big change in culture for a lot of people, and there needs to be understanding I don't think any of us would say that there's a magic wand that, you know, you have one day of training and everything's great. And, you know, there will always be some people who are more receptive to training than others. I think we would always say that as well, and in the judiciary too. But I think it's a real commitment to it, and I think it's a really good step, and I am hopeful that that will have an effect in terms of how these cases are dealt with in the courts.
Okay, and we can talk about this a little bit more, but maybe we could go on to the next slide for now. And the impact, we're getting a couple questions about, have you seen, you know, part of the impact could be unintended consequences for victims, of course. Have you seen, did you address that in your training? Possible unintended consequences for victims where abusers are able to use this new law against them? And did you see that in the implementation?
And I was involved in the training of police officers, and we were very clear, and a huge part of that training was about the manipulation of victims and police officers and social workers and advocates by perpetrators, about how they would try to use all of us to collude against the victim. And I think that was very helpful, and police officers certainly could see it. You could actually see the turnaround of police officers as you went through the day. A lot of, you know, as Sam said, police officers come in, they mirror society. So some would come in with a really good knowledge of domestic abuse, and others would come in with very little. There would be inevitably some victim blaming around at the beginning of the day, but there wasn't a session that I did where the big message at the end was, I never, you know, the depth, the understanding of what coercive control meant, I think was really important, and that was certainly highlighted in the police training.
I think in terms of, you know, talking about unintended consequences, I do remember during the development of the law that was one of the areas that we did talk about quite a lot, about, you know, perhaps women being the law being used against them, you know, that they were controlling, you know, behaviours that, you know, sometimes are, you know, it's like stereotypical behaviours that are deemed, you know, I'm being controlled here, and I think there was a real concern that would be used. But I have to say, looking even at the first year, in terms of the prosecutions, around, I mean, we're still analysing the statistics, and they're going to be published over the summer. Okay. But even just looking at what we have just now, around 96% of the cases involve a female victim and a male perpetrator. So thankfully, I think there's a bit of reassurance that, you know, perhaps those fears haven't, you know, come to pass. And it really underlines the really gendered nature of the crime that domestic abuse is, which is what we already knew.
Okay, thank you for that, Anne-Marie. Laura, was there a question you wanted to pose right here? I'm mindful of the time, so let's hear from Laura about questions, and then please, panelists, be thinking about, you know, the most important thing we want to be sure to get in before our time is up in about 15 minutes.
Sure. We do have several questions. One, I want to go back to the question that Brenda had posed to clarify a little bit. And this question is for Sam, when you were discussing gathering intelligence from victims, maybe regarding other criminal behavior, is the perpetrator or the abusive partner then prosecuted for that other behavior, perhaps drug dealing, for example, in order to provide protection to the victim without her having to go through proceedings based on the domestic abuse, or are both crimes prosecuted?
Okay, so if a victim has engaged with the advocacy service but doesn't want to engage with the police around the domestic abuse, but they have shared intelligence with or information with the advocacy service about other criminality, and that's then shared with us, we can address that other criminality because we have a statutory obligation to investigate crime. So when somebody tells us about crime, we have to investigate it. If that means that we can remove that perpetrator or the person gets arrested for that crime, what we're hopeful that might do, it deals with that criminality, it deals with the drug dealing, and what we're hopeful it might also do is build a bit of breathing space for the victim, and also build a bit of trust in the system, that the system works, and encourage them then to be able to report either themselves in person or through the advocacy service what they're experiencing at home as a victim. Does that cover it?
Thank you. I think so, yeah. Another question is if any of the panelists could talk a little bit about what you see with relation to grooming of the victim. If, you know, in the beginning of a relationship, if certain behaviors which may later become, you know, understood by the system as coercive control are experienced as sort of positive by the victim, does this law help to address that or interrupt, I guess, that process of grooming?
I think, Mhairi, are you coming in?
Yeah, I was going on you go though.
Oh no, I was just going to say that quite a lot of the tactics that we see out of context might look nice, might look loving and affectionate, but actually in the context of domestic abuse and controlling behaviour are not. And that's quite similar to stalking, where a person gets flowers delivered or a gift delivered or whatever, but it's actually the intent behind that action that's there. And we have to identify that, and that's what makes it stalking and not just somebody being particularly nice to somebody else. So we would probably identify that as another tactic that was getting used. Mhairi?
I think the difficulty is that if you've got someone, a perpetrator who's never gone through the criminal justice system before, and they're in that grooming stage at the beginning of a relationship, now that, you know, that there's just no way that would be picked up if there isn't a history. However, if you've got a serial abuser, then bearing in mind what Sam has said, then there are ways that we can pick up things. But and depending on whereabouts that grooming is coming in, is it grooming at the beginning of the relationship, which I think is very, very difficult to capture, and it would depend on how much you could get to the intent behind. But I think if grooming comes in later on, maybe once when the perpetrator is trying to re-establish control, for example, then if there's that period of grooming then I think it's a lot easier to pick up. But initially, I think we have to be honest and say that perpetrators are so manipulative that at the beginning of a relationship, it is so hard to spot. Until you see other aspects of that control coming in, and then having looked at it as a whole, there might be an opportunity.
Thank you.
I suppose it's just the law isn't a panacea to, and it can't capture everything. It's, you know, and I've absolutely no doubt that once it's been in place for a few years, then we'll think, you know what, that could be strengthened by and adding something else.
Thank you. One other question I think that would be good to discuss right now is whether treatment programs or education programs for perpetrators have also shifted or changed in any way with the change in the law to better address coercive control.
Yes, Scotland has the perpetrator programme that is widely used, or not as widely, it's not right across Scotland, but it's in the majority of local authority areas now, as a programme called Caledonian, which is a 2-year programme. And basically it's called the Caledonian system rather than a programme, because it's about ensuring that it's not just about dealing with the perpetrator, it's about providing support to the partner. That it's a really comprehensive system to look at behaviour change. and it started with all the different treatment programmes that there were in Scotland, joining that together and building something out of that. So the Scottish Government put in extra resources to roll out Caledonian. And don't quote me, but I think it's in about 2/3 of Scottish areas, of local authority areas now. So we're getting there. But it's and that's the best that we have in Scotland. We're also looking at Safe and Together. There's quite a significant amount of areas in Scotland adopting that, and we've found that very helpful. So that even where there aren't treatment programmes, that aren't where there isn't the Caledonian, for example, then advocates and others are pushing Safe and Together, so that where there are reports that come into court, then the Safe and Together principles can be used within those reports to actually help build a picture appropriately.
Thank you. Cheryl, there are a couple other questions that are specific clarifying questions about the law, but I know that there's also some information we want to be sure to cover about COVID-19. So maybe we could go on to the next slide, and if we don't get to those questions, I could connect the panelists to be able to answer those.
That sounds like a good plan, Laura. Thank you.
Sure.
We go on to the next one, Nazif. Thank you. So maybe, and this is, maybe you could talk briefly about this one. I think Anne-Marie was going to say a few comments. We do have, just so you know, about 6 minutes left. So if we could move quickly through this one, and then the next one is about addressing violence during COVID-19.
Thanks. I just pulled out some of the behaviours that we've actually been able to successfully prosecute, because I think it's really useful to see that. And for me, this is one of the, I suppose, the strengths and the successes of the legislation. It's only been in for a year. It's not retrospective, so it only captures behaviour from last April. But even within a year, we've been able to prosecute people for courses of abusive behaviour that have included these behaviours that weren't a crime in Scotland until a year ago. So, you know, demanding proof that it's where someone is by having restaurant receipts, or controlling where they go, going to the doctor, access to medication, makeup, clothing, food, drink, behaviours that humiliate and degrade around toileting and having the door open. A lot of use of tracking device and surveillance devices, refusing people to leave the house, isolating them from friends and family. So that for me is, you know, we've been able to prosecute that alongside violence, threats and other behaviours that we could always prosecute. But when you think about the harm that these behaviours cause, and then you think that a year ago those weren't a crime, do you know, I think for me that's the really stark thing. That's the real strength of the law, that it's actually making visible what was the lived reality of people's lives.
Exactly. It just strikes me. This is our criminal laws were designed and written before we understood the harm and these just tactics of inequality that occur with domestic violence. And this is a law now that really gets at women's subjugation and equality with these oppressive tactics. So thank you, Anne-Marie. Let's talk about COVID quickly before we have to end here. Let me just say, as we introduce this slide, we do have an entire webinar series on our website at Global Rights for Women that is court's response to coercive control. Mhairi was involved in a previous webinar on just talking about coercive control during COVID-19. So there's lots of resources in addition to what you're going to hear now.
I think for me, the biggest thing in terms of the problems under COVID has been the court delays. There's been a real issue because courts have been closed down. Scotland is still in lockdown, and we've had 3 months of lockdown, and it's been very difficult for the majority of victims. And that the issue of waiting longer for trials is putting a huge pressure on victims. And it's also, though, again, coming back to the manipulation of perpetrators, then we're seeing that perpetrators know that there's a lesser, it's less likely that they'll be sent to jail at the moment if they breach the conditions than if they did beforehand. So we've had issues recently where there's been a substantive incident and then 3 breaches of bail. So that's 4 incidences, and the person is still out of jail, is still wandering around. It's a slap in the wrist and don't do that again. So for me, the big issue at the moment in Scotland is about the issue around trying to ensure that COVID was not within the jail has resulted in victims' experiences being downgraded. And that is something that I don't say lightly. But it is it gives you an indication of the type of thing where, we're still having hard conversations about the need for change. And the victims, I think the other issue is victims where the abuse was in a way kept to a certain level because of the proximity of other family members, and those other family members not being around now. So that loneliness and that isolation increasing is very, very difficult.
Exactly, hearing that from so many around the world. Other things to add, Sam or Anne-Marie, to Mhairi's comments here?
I think from a policing perspective, we particularly worried about the vulnerability of victims, again, through that whole isolation, through manipulation of child contact and things like that. And we've been working very closely with our partners in the third sector and with the government to try and put measures in place to protect as far as we can. And the message that we've put out across the force and in the media and social media across the country is keep reporting, just keep lifting the phone, keep telling us about it, and we will continue to respond, and we'll continue to investigate it as we would have done before. So it remains a priority for us. It's just particularly challenging because of the environment that we're currently in.
Right.
And I think similarly for the prosecution service, the heads of our organisation have been really clear about saying our prosecution policy and the robust approach we take to domestic abuse has not changed. It's still a priority area. Risk and safety considerations will still be viewed by prosecutors in the same way, but we do accept the constraints and the real challenges that we're all facing with the kind of effective shutdown of a system. We're, working with court service and others to try and look at things like virtual courts and do whatever we can to get things moving. And certainly in terms of the recovery process, priority will be given to cases like domestic abuse, stalking, sexual offending, cases where the most vulnerable people will be. But I think we're all alive to the fact this is going to be a long-term, challenge, and it is crushing, as I said earlier on about all the steps being taken to reduce delay, because we know the harmful impact that it has on people. That this has really blighted that. So I think I think we're all affected by that across, and I know from speaking to other prosecutors in other jurisdictions, even in the US, similar issues as well. So I think we're all just trying to really focus and prioritise these cases where we can to get them back on track.
I am so grateful to you, all of you, Sam and Anne-Marie and Mhairi. You have just been extraordinary in sharing your experience with this transformative, in my view, law. And we're just so grateful to you. And I know our participants are too. We're getting lots of thank yous here, and also lots of resources being shared in our chat box that we haven't been able to get to, something from the UK, Ireland. So we will share those, and this has been videotaped. We'll share the PowerPoint, and we do have to sign off now. Thank you for all of you who joined us and took time to learn about this hugely important transformational law and experience with our Scottish colleagues. So take care, everyone. Access our website. Here's the contact information for everybody you saw here. Thank you again. Bye-bye.
Bye.
Thanks.
Thank you.